If you've ever lived in a community with a homeowners association, you know that feeling. You get that letter in the mail and your heart just sinks a little. Well, today we're diving into a real-life legal battle between a homeowner and his HOA all over a brand new carport. All right, let's get into it. So here's the situation in a nutshell. A homeowner out in Arizona, a Mr. Trezza, decides to build himself a carport back in August of 2019. He thinks it's a fantastic improvement, but his HOA sees a major problem and tells him, nope, that thing has to move. And what starts as a simple disagreement, well, it blows up into a full-on court case. So how on earth did a simple carport end up in front of an administrative law judge? You know, to really get why the judge ruled the way they did, we've got to look at the timeline and the one single rule that caused this whole mess. Yeah, this was not a quick fight. It kicks off in August 2019 when the carport is built, and it escalates fast. By January of the next year, we're talking a formal legal petition. The whole thing drags on for more than a year before they even get a final judgment in November 2020. All of that time, all of that energy, over one specific rule. And this is it. This is the sentence at the very heart of the conflict, straight from the community's rule book, the CCRs. I mean, it's pretty clear. No building will be permitted within 10 feet of any property line. And Mr. Trezza's new carport, it was definitely inside that 10-foot zone. So seems like an open and shut case, right? Well, not so fast. See, Mr. Trezza didn't just apologize and ask for an exception. Oh no, he went on the offensive. He decided to challenge the very legality of the HOA's rules themselves, arguing the rules shouldn't even exist. This was the core of his entire case. He wasn't just asking them to bend the rules for him. He was asking a much, much bigger question. Was the HOA even allowed to enforce this rule in the first place? And he built his case around a couple of really interesting arguments. Okay, this part gets a little into the legal weeds, but stick with me because it is so important. The homeowner's whole argument hinged on this idea that a 2017 vote that approved the HOA rules was totally invalid. He said the ballot was illegal because it broke the state's corporation law. But, and this is a huge but, the HOA shot back, you're looking at the wrong law. For a planned community, a completely different law applies. And under that law, a simple yes vote is all you need. That was a major problem for his case. So besides just attacking the rule itself, Mr. Trezza made another claim. And this is one that I think anyone who's ever dealt with an HOA will find pretty relatable. He said they were singling him out. This is the classic selective enforcement argument, right? The, hey, what about my neighbor defense? He pointed out that other people built stuff without asking first and got approved later. But the HOA's comeback here is crucial. They basically said, look, we're not mad that you didn't ask first. We work with people on that. The real problem, they argued, was the type of violation. His carport was a standalone structure that broke a very specific setback rule, and that made his situation fundamentally different from everyone else's. And he didn't stop there. He also tried to argue that an even older vote from 1993 was invalid, that the rules should have been specially marked as a change in the 2017 documents, and hey, that the HOA's 10-foot rule was just plain unreasonable when the county itself didn't require any setback at all. I mean, he was throwing everything he had, including the kitchen sink, at this case. So you've got this tornado of arguments, counter-arguments, and accusations. How in the world does a judge make sense of it all? Let's break down how it all ended. Now, before we get to the actual ruling, it's really important to understand how the judge had to make the call. This isn't a criminal trial with beyond a reasonable doubt. The standard here was preponderance of the evidence. That's a fancy way of saying the judge just had to be convinced that one side's story was more likely true than not. You can think of it as a 51 to 49% situation. Whichever side tips the scale, even just a little, wins. The judge's decision was incredibly systematic. They just took each of the homeowners' arguments and knocked them down one by one. First, yes, an HOA rule absolutely can be stricter than the county code. Second, that 2017 vote, totally legit, because the HOA used the right law. Third, there was zero evidence the HOA was picking on him. And finally, his request for a special exception was denied. It was, for the HOA, a total victory. But what about the cost to move the carport? The homeowner argued that it was totally unreasonable to make him spend all that money to fix his mistake. Well, the judge's response was blunt. Any money he had to spend was his own fault. By building first without getting approval, he took a gamble. and he lost. And so that was that. The final verdict came down. Petition denied. On every single issue. The homeowner lost the battle, and the carport had to be moved to comply with that 10-foot rule. The fight was officially over. But the story doesn't really end there, does it? The real value in digging into a case like this is what it can teach every single one of us who lives in or is even thinking about moving into a planned community. So what can we all learn from this carport catastrophe? Number 1, read your CCRs. You are legally bound by them the second you buy your home, whether you've read them or not. 2, this case proves HOA rules can be way stricter than city or county laws. 3, saying I didn't know is never, ever a valid legal defense. And that whole build first, ask for forgiveness later strategy, it's an incredibly expensive gamble. And finally, if you do decide to fight, remember, it's on you to prove your case. And all of this leaves us with one last, pretty important question. After seeing how a simple carport can spiral into a year-long legal nightmare and a costly loss, it really makes you think, do you actually know what's in your own HOA agreement? Might be a good time to go find out.